morning, Judge Ahlers.
Good morning.
Feel free to be seated and get comfortable, and when you are ready, you may begin with your opening statement.
Okay, thank you. Good morning. My name is Paul Ahlers. I am a District Associate Judge from District 2B. I want to start by thanking all of you again for your service and also your generosity and flexibility in getting together with me and making it work to meet before today. I am a firm believer that who we are today is a product of our experiences leading up to today and what we take from those experiences. I applied for this position in March, and rather than looking at the outcome of that and not being chosen as a negative, I look at it as having had the opportunity to lay additional groundwork for hopefully what is a successful bid today. To help focus the discussion, I want to highlight the key attributes that I think I would bring to this position. First of all, I bring a strong academic background and intellectual capacity to the job. I finished first in my high school class, first in my college class at Iowa State, and Order of the Coif top 3.4% of my law school class at Iowa. I also have relevant experience as a lawyer. I spent 14 years in private practice, where the primary focus of my practice was civil and criminal litigation, including many jury trials. I also did a fair amount of family law work. Layered on top of that, I also spent 3 years at Travelers in-house with the insurance company there, dealing with complex litigation issues and things of that nature, which I think adds to my experience. I also have relevant experience as a trial judge. I spent almost 8.5 years on the trial bench, where I estimate that about 60% of my time is spent on criminal work and about 30% on juvenile work, which of course makes up the lion's share of the Court of Appeals workload. That experience includes numerous jury trials of both felony and indictable misdemeanor jury trials. I also bring writing and research skills to the table. I was in a very competitive process for getting law review articles published. I was fortunate enough to have both of my articles published when I was in law school. Hopefully the writing materials I've attached to my application demonstrates that I've continued to develop and hone that skill. I also bring a strong work ethic to the table. I'm frequently in the courthouse before it opens and frequently stay after it closes. I'm very proud of the fact that I've never had a case on the 2210 report, which of course is the report we have to file if we have a case under advisement for 60 days or more. I also bring some geographic diversity to the position. I think that is important to have some geographic diversity on the court. I would bring a north central Iowa person to the table, replacing a northwest Iowa judge. I also think there's important to have a nice mix between rural and urban experience, and I have a lot of experience in the rural areas, which I think is important. Perhaps most importantly, I bring a knowledge of the law to this position. As all of you know, I've spent the better part of the last 21 years reading, analyzing, summarizing, and giving presentations about the published opinions of our appellate courts. Besides attorneys, members of the audience frequently include the judges, Court of Appeals judges, and Supreme Court justices who issued the rulings that I'm talking about at those presentations. Not only has that been a form of public service, but I think it has also resulted in me accumulating a wealth of knowledge that I believe sets me apart from the other candidates. Quite frankly, that knowledge base that I've developed over the 21 years of studying this area is irreplaceable. Barely a day goes by where I don't reap some direct or indirect benefit from having engaged in this project for the last 20 years. That project also dovetails into the final attribute that I want to talk about, which is passion, enthusiasm, and energy. Obviously, everybody that applies for this job and goes through this process wants the job, but beyond a bare want, I think we need somebody that will bring a passion, enthusiasm, and energy to the position. And I guess the best way I can demonstrate that I have that in an objective manner is to point to the fact that I've spent vast amounts, more than I'd like to count, spending my free time over the last 2 decades studying the case law of the state and the appellate decisions, and I wouldn't do that if I didn't have a deep love for this interest in this area. So I think all those attributes make me an ideal candidate, and I would welcome any questions that the commissioners have.
Thank you. And so we'll begin with Mr. Horbach.
No questions.
Mr. Bevel.
No questions.
Mrs. Sinclair.
Could you tell me what the difference is between being an associate district court judge and a district court judge?
The primary difference, of course, is the level of jurisdiction of things that you can handle. A district court judge can handle, it's kind of an umbrella. A district court judge can handle everything that I can handle, and then I handle a layer that goes below me that a magistrate could handle and above. So I handle the D felonies and the indictable misdemeanor cases, where a district court judge would also have A, B, and C felonies. District court judges would handle all civil litigation, where mine's capped at $10,000. They also handle family law matters. I don't handle family law matters, but a flip of that would be that I do juvenile matters, and most district court judges don't. Some do, but most district court judges do not. But as I pointed out in my materials, I do think that there's, with respect to the workload that the Court of Appeals has, as far as relevant experience, I think district associate judges frequently have more experience on those key cases that make up the lion's share of the Court of Appeals workload.
Ms. Valentine.
Thank you. The Court of Appeals is notoriously known for its collegiality, and I'm curious what you bring to the table. What can you demonstrate or show us that you would either continue or contribute to that collegiality?
I hear about that a lot as well. I actually spoke to Chief Danielson as part of this process, just to pick his brain about it, and he had mentioned that he had commented to Ms. Roberts that two of the things he wanted was somebody to maintain the collegiality and also the work ethic. So I've heard a lot about that collegiality, and I'm excited about the prospect of being part of that. I think I can contribute to that. I do believe I work and play well with others. And what I'd point to establish that would be some of the letters that I received from, or that were sent to you folks that are on the periphery of my work, whether it's clerks of court or language interpreters or probation officers that talk about my ability to work with other people. But perhaps the thing I'd point to the most, I guess, would be the letter from my ex-wife. Who knows you better than your spouse, and who has more of an incentive to say something bad about you than your ex-spouse, right? So the fact that Susan has a lot of good things to say about me, I think speaks to our ability to put aside personal differences. And obviously, since we're no longer married, we have some very deep-seated differences of opinion on various issues, let's put it that way. Of a very personal nature, and in spite of that, we've been able to work with each other on a cordial and friendly basis and maintain a cordial relationship. And so the way I would look at it is this: if I can put those differences aside and work in a respectful, cordial manner with somebody with whom I have deep personal differences, I'm very confident that I can work with other Court of Appeals judges just because we have some difference of opinion on a suppression issue or something like that.
Thank you.
Thank you.
Mr. Berger.
I have no question.
Ms. Stanger.
Thank you. Hi, Judge Ahlers.
Good morning.
I'd like to hear your thoughts about whether geographic diversity on our Court of Appeals is a valuable factor for this Commission's consideration.
I think it is a valuable factor. I don't think it should be the only factor, of course. The way I would put it is if it came down to me and another applicant, and that other applicant was better than me, but they happen to be from Des Moines, if you're trying to break up an urban Des Moines block, if you will, then I think that person should get it, because I don't think that should overcome everything else. But I think seldom do we have that stark of contrast. You're usually dealing with two good candidates, and then I think the geography is important. I think we are a state with, even though we're fairly small and everybody thinks we're homogenous, we're not. Justice in Des Moines might have a different look than justice in Owine or Webster City or Sac City or what have you. I think things are handled differently. Procedures are sometimes different because of the rural versus urban. So I think that is an important component of it. And I would say even within my three counties of Hamilton, Hardin, and Wright counties, there's different cultures in those three counties. There are things that happen in Wright County that would never happen in Hardin County and vice versa. And so I think it is important to have a spectrum on the Court of Appeals that includes a spectrum of geographic locations.
Thank you.
Yeah.
Ms. Pearson.
No question.
Mr. Gray.
No question.
Ms. Law.
How did your experience at Travelers, will that help you if you're selected to be on the Court of Appeals?
I believe it will, and I believe that from the standpoint that a lot of the things that the story I always tell is, I was in a county seat practice in Webster City, and the first week on my job at Travelers, I coughed up $250,000 worth of policy limits and denied a claim that got us sued out in federal court out in Maryland. And I thought, I'm not in Webster City anymore. Right? And so we won on the motion to dismiss on the lawsuit in Maryland. But so I was right on my coverage determination. But the point is, I think even though the issues that come up from my experience with that are not things that are the day-and-day meat and potatoes of the Court of Appeals workload, I do think they add a breadth and depth to my experience level that can only help me. I got exposure to class action suits and securities litigation and insurance coverage issues, bond coverage issues, bank liability issues, those types of things. And although I wasn't in the courtroom on those when I was managing the litigation from afar, I think that contributes very much to my experience level that I can bring.
Thank you, Judge Ahlers.
Mr. Goodman.
Judge Ahlers, you wrote some in your application about this and spoke a little bit this morning about your presentations on the appellate court rulings. And I just want to ask you a few quick questions about that. First of all, this is at the annual meeting of the bar, is that correct? I have about, this year I'm going to do 6 presentations around the state at various times, but one of my usuals is the annual meeting, yes. Okay. And to get ready for that, you read approximately how many decisions?
It would be all the published decisions, so I believe that's in the 60 to 80 range per year.
And then you have to boil that down into a simple paragraph to say everything and a little bit about the entire case.
Which is a real task at sometimes to take a 50-page decision and pare it down into a meaty paragraph. But yes, that is the goal.
And then your audience includes the people that have written those decisions and argued for and against the outcome.
True. And sometimes the judge that issued the ruling at the trial court level, and sometimes the appellate judge or justices that issued the ruling that I'm talking about. So I always feel like I'm in a minefield waiting for somebody to lob something at me to question me. And I've never had them do that, so I take that as a compliment.
And you've been asked back how many times to make that presentation?
Oh, I'd have to look back through my outline, but the lion's share of the last 21 years, both at Bridge the Gap, annual meeting, Chautauqua up at Okoboji, our 3 regulars, the Story County Bench Bar in January. I've been doing that for probably 10 years. I'm going to have to start saying no to people at some point because it does eat up a lot of my time. Like I said, I'm up to 6 this year that I'm speaking at.
Okay, thank you.
Thank you.
Jeff, I can tell you I'm co-chair of the annual meeting, and Paul speaks on criminal law and civil law, and there's a packed room every time, judges, attorneys. That's one of the most well-attended seminars.
Thank you.
Thank you. Mr. Sukup.
Thank you. Good morning, Judge.
Good morning.
One of the cases you'd referenced and you've talked a little bit about in the past was you had to rule against what you'd really prefer to in that CAT case with the plaintiff versus the defendant, and that sometimes the law oversees it.
Yeah, I had no idea walking into the small claims hearing on that day that case would stick with me as long as it has. But yeah, what happened was there was this plaintiff that had sued for Replevin to recover her cat that she had basically abandoned, and the neighbors were taking care of it in the plaintiff's typical fashion, which was not to exercise any diplomacy, went over and got crosswise with the neighbors who wouldn't return the cat, so she sued him. And it was one of those deals that even during the hearing, she was just an unlikable person. I mean, she was argumentative and aggressive and belligerent, and meanwhile you had these defendants over here who were the nicest people in the world. And I've always, I guess my judicial philosophy is the law is what the law is, and that doesn't mean it can't change over time. But generally speaking, the legal principles are set. We give everybody a fair trial so that we can accurately determine the facts. And then you apply the facts of the law or a lot of the facts however you want to look at it, and that generates the outcome, whether you like that outcome or not. And so in this case, when you do that analysis, this lady was entitled to win. And so I didn't have any hesitation ruling in her favor, but it always stuck with me as a reminder of that judicial philosophy that you have to set aside those likes and dislikes and apply the law and come to the outcome even if you don't like that outcome. And so that case has always stuck with me for years afterwards, reminding me of that detail.
Thank you.
Thank you.
Ms. O'Brien.
No questions, thank you.
Mr. Hoytink.
You just stated that the law changes over time. Can you elaborate on what that means?
Well, I think we have legal principles that obviously need to change at times. Otherwise, we'd still have separate but equal and things of that nature, which are obviously abhorrent to all of us today. So I think the law does have to change, but I also think that I don't know that the court should be leading that change. I think if you want to set policy, you should run for the legislature or the governor. So I don't think we should be leading that change, but I also think we have to be mindful of the fact that things do change, and our standards and what we view as right and wrong changes over time. And it's not willy-nilly, it's not quick, but I think that it does develop over time. So that's what I meant by that comment.
Thank you.
Yeah.
Mr. Spees.
Thank you. Good morning, Judge Ahlers.
Good morning.
I greatly enjoyed the chance we had to visit together in Iowa City. You and I discussed the judicial performance reviews that are done by the members of the bar in each judicial district. How, if at all, have your scores on those judicial performance reviews affected your evolution as a judge?
Well, I would say this, first of all, and I know this is something you take on when you take a public position such as this, but it is a blow to your ego to have your performance evaluation, your job performance broadcast to everybody in the state. But that comes with the territory. So there are some of those scores, obviously, that are not as high as I would like them to be, because obviously I'd like 5s on everything. But I think it is important to keep in mind that all the scores are in the satisfactory to good range, even on my worst scores, and then the good to excellent range on the other scores. I've never lived my life where satisfactory to good is good enough, so I do take that to heart when I get a score that is lower than I would like it to be. I think sometimes what I learn from that, and I do try to use this as a learning experience. I think both as a product of personality and workload, I think I tend to be fairly terse and blunt at times. I'm kind of a get-to-the-point type of person. And I think sometimes that gets misconstrued as arrogance or rudeness when it's not. And so I think if you look at the letters from lawyers that appear in front of me regularly, that would demonstrate that I think they understand that terseness and bluntness, where maybe somebody that just appears in front of me a time or two doesn't understand that that's not the case. But what I can learn from that and do take from that is that I do have to be cognizant of the fact that that terseness or bluntness can be misconstrued, and this might be the only time that lawyer or this litigant appears in front of me, and I think it's important to make sure that you present yourself and your rulings in a manner that takes that into account. I also say that I think the demeanor components are different between an appellate and a trial judge. As Mr. Goodman and I have talked during our private meetings, it would take somebody with a real temperament problem if that leaked out during a 20-minute oral argument, more so than at a long hearing or trial. But with all that said, I think we're all flawed individuals, and we're all to some degree or another works in progress, and obviously myself included. And so I do take to heart some of those areas that I'm not as strong on, and I try to view that as an area of my career and of my life for which I can make some improvement, and I will continue to do that.
Thanks.
Thank you.
Mr. Bloom.
Well, in this process, we get to read a lot, and we've read a lot of cases, trial court rulings on custody or children in need of assistance, guardianship, that type of thing. And we've more recently now started looking at reversals and appellate reviews of those decisions. And it still strikes me as very difficult umpiring. And even in the reversals, I look at it, I'm not a lawyer, but it strikes me that there's gray area that is being applied. And is it important in your mind to have had the experience of being in many of those situations, judging them, having the participants right in front of you, and then later on now as in a court of appeals situation, you're looking back at the facts and circumstances, you're not redoing the trial. Is it important for you in your mind that to be in an associate district court position to do the best job on the court of appeals in those situations?
I do think that, and that's not to disparage the candidacy of anybody that doesn't have trial court experience, but I think having trial court experience is hugely important. I think it helps you understand that in a sentencing hearing there's spontaneous speaking, and sometimes you say something where you're like, oh, I wish I wouldn't have phrased it that way. And if you had had time to map out your speech that you were going to give at the sentencing hearing, you wouldn't have said it the way you said it. And I think it's important to know that, and I think it's important to know how the case gets to you as an appellate judge, and I think having had some time in the trenches to understand how that works, that the transcript doesn't pick up tone, that the transcript doesn't pick up the spontaneity of the interaction between the folks, and the sentencing hearing is the one that comes to mind on that, but there are other examples of that. So I think before I became a judge, I didn't probably fully realize, or I didn't know what I didn't know. And I think that's an important part of our knowledge base, is being able to recognize the things that you don't know, because it causes you then to look into those and research them and try to get some help on those issues, where if you're so oblivious that you don't even know that you don't think to look for that extra help. And I think that layer of experience of having been a trial court judge helps you know what you don't know, and helps you understand what happened when this case got to you, to understand the nuances of that, because there are some flavors to that, I think, sometimes that aren't fully developed in the record or fully stated in the record. So I think that's critically important.
Thank you.
Thank you. Ms. Conover, I don't want to slight you, but we are out of time. Judge Ahlers, thank you for being here today, and we wish you well.
Thank you.
Thank you, Judge, Your Honor.
Thank you.